Okay, the jurors have exited. Mr. Secor, I'm going to ask that you make all of your objections now so that we don't have to keep stopping before each, because they're renewed objections, but a lot of the substance you're having to repeat, or you are repeating for each one. So if you can just make a general objection to each video as far as the 9403 and the cumulative, and then if you want to say the specific amount of times that you believe things are shown, why don't you go ahead and do that now for each video so that we don't have to keep breaking up every witness testimony.
Okay. Hang on just 1 second, please.
Judge, we just want to agree that the state will allow these objections to constitute contemporaneous objections when they publish the individual
Well,
videos.
then all you have to say is over a continued objection, as stated on the record, and then we don't have to use these dreadful headphones and have all these issues, because they seem to be working less and less as the days go on.
We don't have to go sidebar for every time they want to object. They just put it on the record because that's what they're doing.
Right, that's what I mean, but
Right.
that's why I'm asking for you to place your objection on the record now while the jury's out, and then you can just renew your objection at the time the evidence is offered or published.
I understand, Judge, we just don't want to waive any issues that may arise down the road that we didn't make contemporaneous
I don't think
objection.
you'd be waiving it. In fact, I don't know of any law that says you have to repeat every single grounds that you've already stated in order to preserve your objection. I think you can just say, over our renewed objection, and that's it. I don't think there's any law that says you have to repeat all of the same things every time. All of the same arguments every single time. If you are, I'm happy to review the law, but I think that what you're doing is plenty to preserve your objection. Steve, do you agree?
No, for this, I agree with what you said, but what Mr. Secor is doing, and I'm not, laying any blame on anybody or saying they shouldn't do it, but he's also doing anticipatory objections that may come true or may not come true.
I agree.
Because, we're not necessarily going to show Ms. Lapel everything that he says we're going to, or any other witness. So, we don't have any objection to obviously what you said, but the objection should be for what's going on, not what may happen in the future. That's my only concern.
And I just want to, I understand Mr. Seth's concern, and I just want the court to understand that I'm not at all trying to expand my objection improperly. I've received from the state what they say are the videos that they intend to introduce, and I have no way to base my objection on anything other than that. So I understand the concern, but I'm just operating under what I have, which is the only thing that I can operate on.
But if your objection is that by publishing a certain clip of a video to a jury, they will have seen person A being shot and person B being shot multiple times, when there's not been any video of person A and person B being shot, then you're essentially making an objection to evidence that's is not even evidence. So, and the state is saying they may not even show that evidence, and I'm using the example of person A and person B because
I understand. And the reason that I'm renewing the objection is because the cumulative character of the evidence only arises when it's offered. And so that's why I feel the need to put on the record the amount of times that these scenes are shown, because before a video is put before the jury, then the cumulative argument is not the same. It changes every time. And so I'm not trying to interfere with the state's presentation of their case. I'm simply trying to preserve the record accurately as best as I possibly can. So I'm not trying to, again, somehow impede the state's presentation of their case.
And Your Honor, the defense, we have no problem if the defense wants to make a continuing objection without raising the number of times that they believe, not that the state believes, that they believe a victim has been shot. If they want to add the numbers up, if the defendant is sentenced to death and there's a brief in the Florida Supreme Court, the defense will have plenty of time to tally up those numbers from the record on appeal and put it in their initial brief. There's no reason to do it here. They can have an objection that they've already made and just raise it again.
I do want to add also that they bring up the video of Ashley Baez as an objection to Meadow Pollock video. Ashley Baez is on the first floor. It has nothing to do with accumulating Meadow Pollock's video. These are separate victims, separate floors. And the defense brought up Coyer, Martin Duque. Those are first floor victims. We're on the third floor now. There's no cumulative other than the timeline that was presented.
I guess the point that I'm trying to make is I've already denied the defense motion to eliminate, so I did say that you could go sidebar to preserve your objection, but what you're doing is you're repeating and continuing the objection, and it's taking, I don't think it's necessary. I've already denied the motion. The video's in evidence. So what's in evidence can be published to the jury. If you want to have a continuous objection, that's fine. You can state that on the record, but to go sidebar and have you make the argument over and over and over again, I just don't think it's necessary.
And believe me, I certainly don't enjoy making the argument over and over again. I just want to make clear that the reason that I'm doing it is because the cumulative argument changes when a video is shown to the jury. That's the reason that
I understand what you're saying, but you're not just limiting it to that. You are making the entire argument over again, each and every time. And we have 17 videos. I don't need to hear all of the other arguments. You said you were simply going to go sidebar and tell me what you thought exactly was different and that what would be shown to the jury on multiple occasions, but we're going way beyond that.
Yeah, and my understanding was that the court wanted me to make all of my objections, so I was going to go through each of the videos, but I have it in a document, and I can submit it in writing if the court would prefer, and that way...
Didn't you already do that in your motion limiting?
No, the motion limiting did not actually have the descriptions in the way that I have them in this document. It had some brief descriptions that were non-specific because I didn't want to file them publicly, but for purposes of judicial economy, I can put these descriptions and the counts as the defense perceives them in a document, and I can simply reference that when the state wants to show a video, and Your Honor can rule based on that. And I think that would speed up the process. I think it preserves the issue. I just believe that I need to contemporaneously raise that briefly and have Your Honor rule on it before the video is shown.
And Your Honor, the state objects to the defense filing a pleading in writing as to their supposedly contemporaneous objections. It's not contemporaneous if they're going to file an after-the-fact pleading that maybe you give them a week or 2 or 3 or 4 or 6 to put something together and do it after the fact. This is a proceeding that's going on now. They've made their objections. You've ruled on it, Your Honor. All they have to do is say, continuing objection. That's all that has to happen. This doesn't have to be dragged out. They don't have to do anything in writing to preserve their appellate arguments. It's preserved. I understand they don't want to object in public to every photograph that's coming in, but that's the procedure, Your Honor. If they want to preserve their arguments for appeal, just have them object. They don't have to count up how many times they believe that this court is making an error and allowing this in. There are 34 victims in this case with numerous injuries. Yes, there's going to be a lot of photographs, and there are videos. And we see the pandemonium on the 3rd floor. There's going to be videos of that. All they have to say is continuing objection.
I agree. For purposes of preserving your appellate rights, a continuing objection is sufficient. Okay? Is there anything else?
No, I wasn't asking for any time to put together anything for the court. I don't know why that came up. That's not what I was asking.
Okay, but the point is, I've already denied your motion in limiting. I have reviewed all of the videos previous to today and yesterday, and I have found them to be relevant and other things, among other things. So You can preserve your objection by simply saying over the defense renewed objection. But we don't need to go sidebar every time and rehash all of the specifics in order for you to preserve your objection part here, okay? Thank you.
Your Honor, we'll abide by the court's ruling, but it's the defense's opinion that we should be able to preserve the appellate record the way that we believe that we should be able to do it. We believe that the court is limiting our access to the record, but we will certainly abide by the court's ruling. We'd also like to remind the court that on 2 separate occasions, we asked for a hearing outside of the presence of the jury so that we could hash through all of these issues and not interrupt testimony before every witness to have to go through all of this. So we will certainly do what you want us to do, but it's the defense's position that you are limiting our access to the record for the purposes of appeal.
Okay. Respectfully, I disagree. Let's bring the jury in, please. Thank you.